Hello everyone, welcome to the Sure Short topic series for the May 2025 JAIIB exam, and we are discussing the most important topics from our RBWM paper. So these topics, all of these sessions are very important, so make sure that you do not miss any of these topics. These are those topics which have been asked by the institute in almost all the exam cycles, and these are the most probable topics to be asked in your May 2025 cycle as well. All right, so today we'll be discussing the SARFAESI Act. So this is the unit 14 of your module B, recovery of retail loans, and we'll be focusing on the SARFAESI Act and the DRT part today. All right, so let us start. First, when we talk about the evolution of the SARFAESI Act, why did this act came into force, why it was enacted? Basically, to provide a structured platform to the banking sectors to manage their NPAs. So the non-performing assets were stocking up of the banks, and these were hindering their performance. So the securitization and reconstruction of financial assets and enforcement of security interest. This is the full form. This act was enacted basically to enable banks and financial institutions to realize the long term assets, manage problems of liquidity, asset liability mismatches, taking possession of securities, reducing their NPAs. Before the SARFAESI Act came into force, the banks had to resort to the civil courts for getting their unpaid dues, to getting their loans recovered, and this took a lot of time, which became a hindrance, a problem in their banking business of creating deposits, giving out loans. So the SARFAESI Act was enacted, removing this barrier. Now the banks, they can reconstruct the loans, they can go for securitization without the intervention of the courts. All right. And this act was enacted because of the recommendations made by committees like the Narasimham Committee, the Andhyuljina Committee for examining the banking sector reforms. And they considered the need for changes in the legal system to address the issue of the NPAs. So, without the intervention of the courts, the banks and financial institutions have been empowered to take possession of the securities and sell them. So, this act was passed in 2002 to legalize securitization and reconstruction. And to enable this, to facilitate this, the ARCs, asset reconstruction companies, or the securitization companies are created or formed. So basically, banks, they create a pool of their NPAs, they sell them off to the ARCs. ARCs create security receipts and forward it to various investors. These are the qualified institutional investors. All right. So the passing of the NPAs from the bank's books to the ARC, and the ARC in turn make immediate payment to the banks so that the banks can continue with their banking procedures. Now, what are the provisions under the SARFAESI Act? It calls for securitization of the financial assets, which means selling of the securities which are kept as a mortgage, let's say, against a loan, reconstruction of financial assets, recognition of any interest created in the security, the power to enforce a security, and a central registry has also been created, the SARSAI. The central registry, why? For the purpose of registration of transactions, also for the registration of any loans that are created, so security interest and charges. The central registry also maintains the documents regarding all the charges which are created, so that the banks, they can check whether or not this property which is being, let's say, kept as mortgage by the borrower, it is unencumbered or not, right? So the securitization, reconstruction and creation of security interest, for these purposes, the central registry has been formed, right? Now, when can the banks initiate the SARFAESI Act? There has to be a minimum amount of time for which the loan has remained in the bank's books. Only after that, the banks can take the SARFAESI route, right? So the loan must have been classified as an NPA. There are various categories of NPA, doubtful assets, standard assets, which we'll be discussing in further sessions. Then the outstanding in the account, including the interest, should be more than rupees 1 lakh. All of these points are very important. Direct questions can be asked, like for the Security Act to be initiated, the outstanding in the account, including the interest applied, should be more than dash, and you'll be given options rupees 1 lakh, 2 lakh, 3 lakh, 5 lakh. So you should remember rupees 1 lakh, or you can be given statements. Which of the following conditions should be satisfied for initiating the SARFAESI Act? So you should remember all of these points. The outstanding due should be 20% or above the principal and interest. The secured asset should not be an agriculture land. The banks or the financial institutions cannot sell the agriculture land if it is kept as a security by the borrower. Documents should be enforceable and unexpired, period of a minimum of 6 months, and in case of multiple lenders, let's say from one borrower there are multiple lenders who have NPAs in their accounts, in their books, so they can together file the application. So in case of multiple lenders or consortium of advances, ensure lenders having a minimum of 60% of dues are agreeable for initiating action. So all of these 6 points are very important. All right. Then what is the process of enforcement of the security interest? Once the account is classified as NPA, the SARFAESI Act empowers the secured creditor. Secured creditor is the person who has gotten the charge registered with the central registry. For example, let's say any borrower, Mr. X, has taken a loan from a bank XYZ, but bank XYZ has not gotten the charge registered. Then the same person, Mr. X, on the same mortgaged property, has taken a loan from a bank ABC, and bank ABC has gotten the charge registered. So now the bank ABC is a secured creditor, and only the secured creditor can initiate the SARFAESI Act. All right. So doesn't matter, even though the loan was given first by the bank XYZ, then also only the secured creditor will initiate the act, right? So the secured creditor can issue a demand notice to the defaulting borrowers, mortgagors, or guarantors. So before securitization or reconstruction, first a 60 days notice will be given to the borrowers, mortgagors, or guarantors, within which they have to discharge their dues in full. Otherwise, if within 60 days they do not pay off the debts, then the securitization process can be started, right? In this notice, the details of the amount payable should be given, and the details of the security should be given. Also, the details of the defaults, overdue period, facility wise securities, the date from which the account is classified as NPA, all of these can also be given. Mandatory are two information: details of the amount payable and the details of the security. Again, very important. Which of the following is mandatory to be given in the notice given to the borrower? So, only the amount payable and the details of the security. All the other information is optional. Then 60 days notice is given. If the borrower is aggrieved by this notice, then what they can do, they can raise an objection within 15 days of the receipt of such representation. However, if the borrower does not comply with the demand notice, then the secured creditor can take recourse to the recovery measures. They can take possession of the secured asset, they can take over the management, which is known as reconstruction, they can appoint any other person as a manager, and so on. So there are various options available with the secured creditor to start with the SARFAESI Act. And this is without the intervention or adjudication of the court, without the interference of any civil court, right? If the borrower is aggrieved, they cannot take the case to the court because SARFAESI Act gives the right to the secured creditor. And once the borrower receives the notice, they cannot transfer any of the secured asset by the way of sale, lease, or otherwise without the prior written consent of the bank. And if they do so, it will be a criminal offense. They shall be punishable with imprisonment for a term which may extend to 1 year or with fine or both. So now they cannot transfer, they cannot dispose of the property. If they try to do so, if they try to dispose of the property, transfer the property, sell it off, they will be punished, right? And when the bank is taking the possession of the secured assets, it would be done only by the authorized officer in presence of two witnesses. This is the steps to be followed. Then steps for the disposal of the movable assets should be taken to avoid the safekeeping expenses, security charges, deterioration of quantity or quality. And if we are talking about a mortgaged immovable property, immovable property is which is attached to the ground. Let's say a house, a building, or a go down, anything which cannot be severed or it cannot be separated from the land, that is the immovable property. So when we are talking about movable property, it can be goods, it can be assets, they can be easily moved from one place to another, stored in the possession of the secured creditor. But when we are talking about immovable property, how will then the secured creditor take the possession? They will take the possession by delivering a possession notice to the mortgager. They will paste the possession notice at the door of the conspicuous place of the property. They will also, within 7 days, this is very important, within 7 days, they will publish the possession notice in two leading newspapers, one of which should be in vernacular language. One can be in English, another will be in a local language which has sufficient circulation. So, this is how the secured creditor will take possession of the immovable mortgaged property. Alright, they will affix the notice at the place. They will also publish the notice in two leading newspapers and they have to do so within 7 days. And for taking the possession, the authorized officer can take the help of the chief metropolitan magistrate, the district magistrate, or the chief judicial magistrate. And if this period or this application has to be filed and the decision is to be taken within a period of 30 days, the chief metropolitan magistrate or the district magistrate, they will they will be satisfied with the content and they will help the authorized officer. They will give their orders within a period of 30 days. However, if no such order is passed within 30 days for reasons beyond control, another 30 days can be taken and within 60 days the order should be passed. Right. Now, what if any person is aggrieved by the decision of the secured creditor, financial institution, the bank? Let's say a house was given as mortgaged by the borrower. But in this house, any tenant is living, and that tenant is aggrieved by the measures taken by the secured creditor. Then they cannot file a complaint with the court. There's a separate debt recovery tribunal. So the appeal can be made to a debt recovery tribunal within 45 days from the date on which such measures are taken. Let's say the possession notice is pasted or the possession is taken by the bank. So within 45 days from the date on which such action is taken, an application to the DRT can be made. There's a separate act for this. There's the Banks and Financial Institution, the Recovery of Debts Due to Banks and Financial Institutions Act 1993, We also call it as the DRT Act, and the rules made under, but they have to dispose of the application within 60 days. So the DRT, they will receive the application, they will hear the what both the parties have to say, and they will give their decision within 60 days, right? If, however, the application is not disposed within, let's say, 4 months, then any party to the application, that is the aggrieved person or the bank, they can approach the appellate tribunal. So there's the DRT and the DRAT, Debt Recovery Appellate Tribunal. Or the person is still aggrieved with the decision that is taken by the DRT, then also they can file an higher appeal with the DRAT for the early disposal of the application. But before this, we said that within 45 days you can file an application to the DRT. And after the decision is taken by the DRT, then within 30 days you can also file a higher appeal with the DRAT. But now, if you are making an appeal to the appellate tribunal, you have to first deposit 50% of the debt demanded by the bank or determined by the DRT. Again, very, very important. When you are making a complaint to the DRT, at that point, no deposit is required. But when you are filing an appeal to the DRAT now, the appellate tribunal, then you need to deposit 50% of the amount which is decided. It can be reduced to 25%, but we will remember 50%. In case the DRAT finds out that wrongfully the possession is taken by the secured creditor, then the secured creditor is required to pay compensation. And once the possession is taken, the authorized officer will obtain valuation of the property. Let's say the mortgaged house. So what is the value of the property in the market? Is it enough to recover the whole dues of the secured creditor or not? If not, then other properties can also be taken, right? So what will the authorized officer do? The authorized officer, after getting the valuation, they will fix the reserve price of the property in consultation with the secured creditor. Reserve price is the first price which is at which the property is to be auctioned, right? And the authorized officer should serve 30 days sales notice. Along with the sales notice, they will tell the borrower or the mortgager what is the reserve price which is fixed by the authorized officer, the date, time, and place of the public auction, or the time after which the sale or any other mode shall be completed. At this point of time, also, before the sales notice is given, if before that the borrower or the mortgager they have paid in full their dues, then also the property will be returned. So this is also an important provision. The bank or the act allows that before the public auction all the time, if the borrower is making their dues in full, then the property will be returned. Now, if we talk about the auction, so in the auction, reserve price should be fixed at 95% of the fair market value. Let's say the fair market value is rupees 1 crore. So 95% of it will be the reserve price. It is the first price. If there is no bidder at the reserve price, then the in the next auction, of which the time, date, and place will be informed, the price may be fixed as the forced sale value. Again, very important. The institute can ask us, what is the price fixed for the sale of the property in the first auction? It is known as the reserve price. And what is the price fixed for the second auction? Then it is known as the forced sale value. What should be the reserve price? It should be 95% of the fair market value. All right. Then sales notice should be informed, affixed at the conspicuous place of the immovable property. It should also be available on the website of the bank. 30 days sales notice should be given for the first sale and minimum 15 days for the subsequent sale. This is also important. Again, direct questions can be asked. How many days notice should be given for the first sale? 30 days. How many days notice for the second sale? at the forced sale value, minimum 15 days. All right. And the mortgager has the right to pay the dues to the bank and redeem the property at any time before the date of publication of notice for the public auction, or inviting quotations or tender from the public or private treaty. So before the 30 days or 15 days notice, if the mortgager pays all the dues to the bank, they can redeem the property. All right. And the provisions have also been made that e-auction should be done, electronic auction should be done for the sale through SARFAESI, except when the at the time of auction the book value is less than rupees 5 lakhs, or the forced sale value is less than 5 lakh. So if it is more than 5 lakh, then e-auction is compulsory. Less than 5 lakhs, e-auction is not compulsory. This is also an important point. Then we have discussed about the DRT and the DRAT. Let us see what is the role of DRT and the DRAT. The Debt Recovery Tribunal or the Debt Recovery Appellate Tribunal. These are established under the Recovery of Debts Due to Banks and Financial Institutions Act of 1993. Right? These are apex bodies to settle the recovery issues in case of loans extended by the financial institutions, for helping the financial institutions to recover their bad debts quickly and efficiently, right? Various amendments have been made, rules have been formed to help initiate the SARFAESI Act. So the setting up of a DRT is dependent upon the volume of cases. So if in a particular territorial area the number of cases are higher, more DRTs would be set up, and DRTs are located all across the country, right? So the DRT shall exercise the jurisdiction, powers, and authority to entertain and decide applications from the banks and financial institutions, right? The DRT is presided over by a presiding officer. DRAT is presided over by the chairman or the chairperson. The presiding officer's qualification is very important. They should be qualified to be a district judge. Either they have been a district judge in the past, or they're qualified. They have the qualification of a district judge. And they're appointed by whom? They're appointed by the central government, right? And the orders which are passed by the DRTs are comprehensive orders like in civil courts. So the DRTs have the powers equal to a civil court, although the presiding officer need not be a judicial officer. Right? So the DRTs are fully empowered to pass comprehensive orders like in civil courts. They can hear cross suits, counter claims, and allow set offs, right? But they cannot hear claims of damages or deficiency of services or breach of contract or criminal negligence on the part of the lenders, right? Only related to the NPAs, the bad debts, the DRTs can hear the suits. So this is also very important. The institute can ask us. The DRTs cannot hear claims for which of the following? So for the damages or deficiency of service, breach of contract, or criminal negligence. All right. All the evidences are taken by way of an FE debit. Right. Now, when we are talking about the enforcement of the DRT, which acts can be taken to the DRT, or the appeal can be filed before the appellate tribunal? Only for the cases which are more than 20 lakh rupees. So, the provisions of the Act shall not apply where the debt due to any bank or financial institution is less than 20 lakh rupees. So, more than 20 lakh cases are heard by the value of 20 lakh NPAs are heard by the DRTs. All right. And then there's fee which is payable, which is not that important. When the amount due is 20 lakh, then 12,000 fees is to be paid. Above 20 lakhs, for the amount above 20 lakhs, plus 1,000 for every 1 lakh amount. All right. So these are the fees. So when the DRT receives a complaint or an application, they will issue summons to the defendant. So the person who is making the appeal to the DRT is known as the complainant. And against whom this complaint is made is known as the defendant. So the DRT will issue summons to the defendant requiring him to show cause within 30 days. So let's say the borrower has filed a complaint with the DRT saying that the measures taken by the secured creditor are not correct. Then 30 days time will be given to the defendant as to why the relief prayed for should not be granted. Interim order can also be given against the defendant to debar him from transferring, alienating, or otherwise dealing with the property. Let's say here now the defendant is the borrower. Bank has filed a complaint that the borrower is not paying the dues. It has become NPA. So the DRT will pass a temporary order saying that the defendant cannot transfer the property, right? Then the DRT will give opportunity to both the sides and then pass an interim or a final order. What if any person is aggrieved by the order passed by the DRT? They can file a higher appeal to an appellate tribunal within 30 days. However, there's something which is known as ex parte decision. Ex parte decision, or let's say one sided decision. There's another thing when one sided decision is taken. Let's say the borrower had filed an appeal and appellate tribunal had asked the lender to provide some documents, but the lender has not complied with the order. Then ex parte decision will be taken. That is ex parte on one side. What if the parties they had agreed to a decision and then the order was given by the tribunal? Then against that order which is made with the consent of the parties, no appeal shall lie. And we have already discussed within 30 days from the date on which the copy of the order is received and depositing 50% of the amount, the appeal can be made. However, it can be reduced to 25% if the DRT finds it appropriate. Then, within 6 months from the date of receipt of the appeal should be disposed of, and there's no provision of the act for further appeal. So, the decision or the order passed by the appellate tribunal is final. Now, any person, cannot file a higher appeal with the High Court or the Supreme Court, except for writ jurisdiction, right? There's also the Limitation Act. Within how many years the banks can file a recovery application with the DRT? Within 3 years. If 3 years have passed of the loan has become NPA, more than 3 years have passed and the bank has not filed the recovery application. So now it will become a bar. It will become a bar. This is the Limitation Act. It limits the time period, right? Then what are the modes of recovery? The DRT or the recovery officer, they will receive the copy of certificate. The DRT has made the decision, they have passed the order that yes, recovery should be done. So who will do the recovery? The recovery officer. They will receive the certificate and they can take any step, attachment and sale of the movable or immovable property, taking possession of the property, arrest of the defendant and appointing a receiver for the management. Let's say they want to improve the management. They can themselves manage or appoint any third person to manage the movable or immovable property, arrest the defendant. Let's say they're trying to dispose of the property, then the defendant can be arrested and up to 1 year's prison can be given to them. These are the modes followed by the recovery officer. Other thing, there's something which is known as a waterfall arrangement or the sequence. Let's say the Mr. X who had taken a loan from three banks on the same mortgaged property. So out of these, which bank will have the priority? Let's say the mortgaged property's market value is rupees 50 lakhs and the loan which is given to bank A is of rupees 20 lakhs, bank B is of rupees, let's say 10 lakhs, and bank C is of rupees 30 lakhs. So, who will get the priority of the first payment? The bank who has gotten the charge registered and which is known as the secured creditor. So, the rights of the secured creditors to realize secured debts due and payable shall have priority over all the other debts and government. Even government dues, taxes, cesses, state government or local authority. Even before that, the priority will be to the secured creditor. Right? This is an important point. Then we said that more than 20 lakh values NPAs can be taken to the SARFAESI Act to the DRT. What about those cases in which the amount is less than 20 lakh? These will be heard by the Lok Adalat, which is translated into People's Court. So it is the easiest, cheapest, and fastest mode. Here, the one-time settlement can be put through the Lok Adalat, and the Lok Adalat is organized under the provisions of the Legal Services Authorities Act of 1987, not under the Lok Adalat Act or the DRT Act or the IDRBT anything. No, only under the Legal Services Authorities Act of 1987, right? So it is easiest and cheapest because free and competent legal service is provided to the weaker sections of the society. That section which cannot pay very high fees. For them, the Lok Adalats are established. Securing justice are not denied to any citizen by the reason of economic or other disability. So, on the basis of equal opportunity, the Lok Adalats are established. And Lok Adalats are established at four levels. There is the National Legal Services Authority, the Legal Services Authority of the state, District Legal Services Authority, and the Taluk Legal Services Authority. So, in every state authority or district authority or Taluk Legal Services Committee, they can organize Lok Adalats. So, if the institute asks us who can organize Lok Adalat, so every state authority or district authority or Taluk Legal Services, it depends upon the number of cases which are there in a particular area. All right. And how does the Lok Adalat provide fastest resolution? They try to arrive at a compromise or settlement between the parties. And the orders which are passed are deemed to be a decree of the civil court. Also, the decision which is made by the Lok Adalat shall be final and binding on all the parties. Why? Because it was with the consent of both the parties through compromise and settlement. No appeal shall lie to any court against the award. Now, the case can be taken directly to a Lok Adalat or it can be referred by the High Court or any other civil court. When a case is referred by the any other court, then and the order or the decision or the issue is resolved by the Lok Adalat, it is resolved. Then the fees which is paid by the defendant or the complainant, it will be returned by the court. However, if let's say it was referred by the any other court to the Lok Adalat and the Lok Adalat could not resolve it, then the case will be sent back to the court and it will start from the point at which it was left. This is also very important. All right. So the recovery of accounts outstanding up to 20 lakhs can be taken to the Lok Adalat. Right. So the banks need to identify the dues up to rupees 20 lakhs, whether secured or unsecured. Under the DRT, under the SARFAESI, only secured acts or the secured NPS could take. But in the Lok Adalat, there is no such restriction. Whether secured or unsecured, the NPAs with dues up to rupees 20 lakhs can be taken. So the bank shall prepare a petition separately for each account. Pooling of the accounts cannot be done as was done in the SARFAESI. Then the cases are referred to the usual Lok Adalat, the district or the state, and the banks can also organize Lok Adalat with other banks in a locality, right? Then the Lok Adalat will be organized and the order will be passed even on a holiday. Then these points are very common. The concerned branch of the bank will personally contact the borrower. They will convince them to attend the meetings. They will ensure that the parties are present at the Lok Adalat. All right. So, when we are talking about the Lok Adalat, it is presided over by a sitting or a retired judicial officer with one or two other members. These one or two other members are loyal, can be a lawyer and a social worker. And when a decision is passed by the Lok Adalat, what happens then? The borrower will have to make the payment. They can make a down payment of the awarded amount at the time of the settlement itself. The whole amount can be paid, or the full payment within a short duration. Let's say within 1 month, the borrower says that I will make the payment, or it can be full payment, can be done in installments also, right? So at the time of settlement, the payment can be made, or at the time, let's say 1 month, the borrower says I will make the full payment after 1 month, or they can make a down payment, a small part of the full payment at the settlement. Many or all of these options are available, right? So, however, in the event of failure to honor the Lok Adalat commitments, then the proceedings will be initiated immediately, right? That is, the case will be sent back to the court. Like we discussed, if a case is referred by any civil court to the Lok Adalat and the Lok Adalat could not give a resolution, it will be sent back to the court. But if the decision is taken, then the entire court fee paid for filing the suit will be returned back to the complainant. All right. So that is all about the SARFAESI Act and the DRT Act and the Lok Adalat. Both of all of these are very important. Many questions, or we will say in all the exam cycles, institute has asked repeated questions from these topics. So make sure that you understand these topics thoroughly. If you have any doubts, any queries, you can let me know in the comment section. We will in the next session discuss about the types of NPAs, provisioning requirements, the different types of standard assets and recovery policy of the banks. That is all for today. I hope all of the things that we have discussed are clear. I will see you again with other important topics. Please follow these sessions very diligently. These are very important from your exam point of view. And that is all for today. Thank you so much. All the best. And don't forget to like, share, and subscribe.